Good evening, everybody, and welcome to this evening's live Tenant Farm Association webinar. What does it mean to have the quiet enjoyment of the holding? So before we start, I have some housekeeping to talk through. I'm Robert Martin, and I'm the National Chair of the Tenant Farm Association, and this event is kindly sponsored by Roythornes Solicitors. For those that don't know, Roythornes is a national law firm steeped in agriculture. They have 90 years expertise advising landowners and tenants alike. Their lawyers are active in farm tenancy policy groups. They get the bigger picture. So whether it's a succession application under the AHA or a new farm business tenancy, a dispute with your landlord, a share farm agreement or a collaborative natural capital agreement, Roythornes are there to advise and assist. If you miss tonight's webinar or you want to rewatch at a later time, it will be recorded and once edited will be available on the TFA YouTube channel. To find our channel on YouTube, search for @Tenant Farmers. The TFA video library features all the past visual events, knowledge share, teachings, and any key snippets. We encourage you to pay a visit and subscribe to the channel so you'll be notified when we upload any content. So to find us, you will find us at Tenant Farmers. So moving on to this evening's event. Tonight we're very pleased to welcome Harry Russell, a solicitor in the dispute resolution team with our partners this evening, Roythornes Solicitors. Since qualifying in 2023, he has quickly developed expertise in agricultural tenancies, landlord-tenant disputes, and commercial issues affecting agricultural businesses. He is also a member of the Agricultural Law Association and has acted in judicial reviews concerning regulation in the food industry. But following our short presentation from Harry, we'll then be joined by our Chief Executive, George Dunn, for a live 30-minute question and answer session. So this is your opportunity to engage directly with our expert speakers to clarify the related topics. So with no further ado, I would like to hand over and start tonight's webinar by handing over to Harry. Good evening, Harry.
Good evening, Robert, and thank you very much for that very kind introduction. So, as alluded to, I'm one of the disputes lawyers, so I get involved when things have gone wrong, essentially, or when things might have gone wrong. So really, my perspective when dealing with these matters tends to be exactly that. Where is this going to come unstuck? I'm not the one that drafts the agreements, I'm the one that reviews it after something happens. I work with Roythornes, been there for a few years now, and you've had a bit of an indication of the sort of thing we do. Now, today, the focus of what I'm going to be talking to you about is very much about the dynamic between the tenant, yourselves, and your landlord. So the relationship and the covenant of quiet enjoyment and how that fits within that context. So if I can move to the next slide, the question is, what does it mean? Now, quiet enjoyment, I think, is a bit of a misleading term. It has nothing directly to do with noise. It doesn't really mean that you have to be having a great time on the property. What it means is that you are effectively the landowner for the duration of your tenancy. You are entitled to possession of that property for your lawful activities without the interference or interruption of the landlord. And the quiet enjoyment covenant is effectively the promise made by the landlord to let you do that and not to interfere. So quiet enjoyment, I think, can mislead some people, and it sometimes strays into the area of nuisance, which deals with third parties rather than the landlord and tenant relationship. And it does also interplay quite a lot with various other legal points, which I'm not going to go into here because it's outside the scope of this, but you rarely have just a quiet enjoyment breach issue. You might have quiet enjoyment breach as well as a whole spectrum of other issues with your landlord. But as I said, it's fundamentally down to this possession of the property without undue interference. Now, on the next slide, we've got the question of how it applies to you. And the starting point is, what's your tenancy agreement? What's the agreement that you have with the landlord? Many of you might not have a tenancy agreement, but those that do, fundamentally, it's often includes this express clause, so specific wording that will say something along the lines of the landlord covenants with the tenant to grant them the quiet enjoyment of the holding for the duration of the tenancy. That's kind of the shortest form version of such a clause, but they do vary. So you might have one that's a bit more narrowed down. You might have one slightly wider. So you might have one, for instance, that extends to the landlord above the landlord. If, for instance, you're a subtenant. But it does vary. Now, don't be alarmed if you don't have a written agreement, or you have a written agreement that doesn't have an express clause here, because essentially the default position is it will be implied in. It's really a fundamental part of the lease picture, whether agricultural, commercial, residential. There is an expectation that there will be a quiet enjoyment clause, because, like I said, when you're entitled to the exclusive possession without undue interference, it's a building block of a lease arrangement. Now, one of the things that we're going to talk about quite a lot in this talk today, and I expect in the Q&A afterwards, are reserved rights of the landlord, because this is something you do have to consider in the question of the quiet enjoyment covenant. You will, I'm certain, in any tenancy that you guys have experienced, have had situations when the landlord has wanted to come onto your property, he's wanted to inspect something, maybe he's wanted to check you're keeping up with any repairing obligations that you have, or maybe he wants to carry out some surveys. And often those are enshrined in the agreements by the way of reserved rights. Effectively, if the landlord has a reserved right, and he's acting lawfully in exercising it, he's probably not going to be in breach of his quiet enjoyment covenant to you. But it's a question of fact and degree. It's a question of is he acting reasonably? And on our next slide, we'll start talking about really where the issues might arise. And if you've ever dealt with lawyers, you probably know that we're quite good at hedging our bets. We quite like the words "it depends." And this is no different in this circumstance, because a question of whether you have an issue of a breach of quiet enjoyment covenant is always very, very fact specific. You have to consider the tenancy picture, the agreement between you and the landlord, the reserved rights that fall within that, and the actions which feasibly could lead to a breach of it. So it's never clear cut. And you have to consider the landlord or their agents, because it does extend to people acting in their direction. They could be acting lawfully in the exercise of their rights. But let's explore this picture. What does a breach look like? And I've listed a few examples here in terms of blocking access. This could be quite a clear-cut one. You could have a driveway to your let land. Maybe it crosses over the landlord's freehold property, but you have to cross it to get to your land. Let's say he puts a new gate on and he locks it and he prevents your access because he hasn't given you a key. Now that's a very clear breach of some sort of term, whether that's your right-of-way easement or whether it's a breach of quiet enjoyment covenant. Very likely both, because he's preventing you from enjoying your property. Now, I would hope that you're not going to get in that sort of situation, but I'm afraid it does happen. And ditto with the interference with utilities point. There are sadly examples of landlords trying to pressure tenants for one reason or another, and it can get quite bitter at times. Indeed, there's case law where, for instance, landlords have simply cut off the electricity or gas supplies, and that's been found to be a breach of the quiet enjoyment covenant for obvious reasons. You can't really make use of the property that you're in a contractual agreement in the form of a lease with the landlord when you don't have the utilities there. In those circumstances, those are clear-cut cases, like I said, so a court will act swiftly to reinstate the position. I'll talk about how they do that a little later. It gets a bit more nuanced in this fact-specific scenario, though, when you don't have those clear-cut scenarios, which is by and large the typical scenario. There are heaps and heaps of cases where this has been argued in the courts. And frequently the tenant is successful. Sometimes they push it too far. You really have a full spectrum of situations here. There are some quite interesting cases, though, which kind of illustrate the situation and how a court will approach the issue of whether or not there is an issue, whether there is a breach. For instance, there's quite an old case which I find quite interesting. It's called Sanderson and Berwick-upon-Tweed Corporation, where you have a landlord and three tenant farmers, all beneath the same land. And you have, in this case, a flooding issue, which might not be something you immediately think as a breach of a quiet enjoyment covenant. But what happens is the tenant farmer who brings the claim, his property is adjoined by two other tenant farmers. There's flooding issues from both of those properties onto his, and he's lost a whole heap of crop because of it, because his fields have gone underwater. Now, he brought a claim for damages for the result of the loss of the crop, and the end result was he brought it against the landlord, to be clear, and the end result was that in the case of one of the instances of flooding from one of the properties, the landlord had breached his quiet enjoyment covenant, and in the other he hadn't. And the reason for that was because in relation to the one where he had, the drains weren't in a good state of repair. And the landlord had effectively not maintained that, whereas the tenant on that property had been simply just using the drains in a lawful manner, not excessively at all, and it was by no fault of his that the flooding then occurred on this claimant farmer's land. But in relation to the other one, the drains were in good repair, but that tenant had been acting excessively and trying to put far too much water through that supply, and that's why that had flooded. So you have quite a bizarre situation, but it comes down to this question of whether or not the landlord has been acting reasonably and whether he has acted lawfully in relation to the breach. That question of reasonableness is something that the courts are very keen to assess. So you might well find that if you bring this question, the court will be very keen to assess how the landlord has sought to work with you to mitigate any potential breach of the quiet enjoyment covenant. If he wanted to undertake a whole heap of repairs, fulfillment of his repairing obligations, and to access your property to coincide with that, to prevent it becoming too undue and interfering with your activities, the court will likely have wanted to see that landlord has, for instance, worked with you to find the suitable days, to work when the works can actually take place with the minimal interruption to your activities. So, for instance, you can still bring in your crop and not find that your yard's full of lorries and building contractors and things like that. If the landlord's simply just steamrolling the matter and ignoring your concerns, then that's an indication that they could well be breaching the quiet enjoyment of covenant and exceeding the reserved rights that they may well have granted to them. So, if we go to the next slide, we can consider when an issue has arisen, what do you do? Now, some of these are going to be quite common sense, but they are the options, in short, that you have open to you. First point, is you could just wait and see what happens. You could accept the situation for now if it's not that severe, or if it's not really causing that much damage. It's a bit unpalatable, that one, but it is an option, and so I am noting it. Now, the next is really the first port of call in most situations. If you have an issue, let's say, I know the landlord has a shoot, they've come onto your land, and they've trampled some of your crop, go and have a word with the landlord. Or even better, if you've got an agent, go and send your agent to have a word with the agent for the landlord, and they can have a more sensible commercial discussion. I often recommend that to my clients where possible, because my experience as agents can take a lot of the emotion and fractious elements that you sometimes get in these relationships and have a more proactive and sensible progressive discussion. Now, the third point I've got listed here, seek advice. We are in a TFA talk, and you are, I hope, all members of the TFA. It's a very good resource for you guys to have. If you think you have a problem, I'm sure the TFA can speak to you about potential fixes to that issue in the first instance, and you should take advantage of that. Other than that, you could go for more specialist advice in the form of solicitors and barristers, but that often comes after. I would suggest, use the cheap or the free options available first, and indeed there's a whole range of online guidance as well. But if you do want something more comprehensive and assesses the legal picture, you can certainly go and seek some legal advice in relation to it. And that all leads to whether or not you need to bring a claim. And bringing a claim is, I would suggest, often the last resort that you should seek to, because it's normally the result of what happens when you haven't been able to have a sensible discussion to fix the problem. And what does a claim look like? Which is a point I consider on the next slide. So if we start at the end, what are you after? We take one of the examples of what might happen with an instance of a breach. let's take this trampling of a crop. Shoots on the neighbouring land. They come and trample your crop because they've accidentally trespassed. It's the landlord's shoot, so he's clearly responsible. It's people acting at his direction, or he's participating in it, and it's deriving from his land. So it's clearly a question where the tenant and landlord relationship is relevant, and therefore the breach of the quiet enjoyment covenant, and whether that's been breached. In that sort of circumstance, it's most likely a damages question. What is the cost to put you back to the position where you should have been? And that will be via a damages claim, with the value being whatever you're out of pocket. So the value of the crop, the cost of rectification, something like that. That's not the only remedy. You might find that damages aren't an adequate remedy to fix the problem, maybe because the landlord's acting so unreasonably, he's simply preventing you access, or he's preventing your total use of the holding, or in such a substantial way that it can't continue. In those circumstances, you'll want to consider an injunction. And I'm not sure whether you've come across an injunction before, heard it discussed. Hopefully you've not had a reason to pursue one, but this is quite a severe remedy through the courts, but it's absolutely applicable in instances of breaches of quiet enjoyment, where you can't seek damages instead. An injunction, by way of explanation, is a court order which essentially compels a party to either do a thing or to not do a thing. So, as an example, it might be the landlord has to remove a block to an access way, or it might be that the landlord has to refrain from carrying out an activity which is causing the issue. And the reason why these are quite a severe remedy is because it's a strong form of court order. And if that person that is subject to it then breaches the order, they're at risk of what we call contempt of court proceedings. And this has pretty severe ramifications for the party in breach, because it can eventually lead to criminal sanctions right up the way to a custodial sentence. So somebody that is repeatedly breaching a court order, like an injunction, could ultimately find themselves in prison. So it's a pretty strong form of protection for you. Now, the other point I will note is potential remedy of essentially rescinding the contract. You could have a breach that's really just invalidated the contract between you. Often that's not something you want to do. You want to just be put back to where you were, but it might be that the relationship is gone and the landlord has damaged the situation so severely that this essentially gives you an option to get out. That's really quite uncommon, but it can arise, and it might be an option you want to consider. Now, I mentioned before that quiet enjoyment covenants and the breach of them can interplay with quite a lot of other legal concepts. There's the issue of nuisance, which often comes into play, something called derogation of grant, which you may or may not have encountered, but there's quite a lot of common ground between that and the quiet enjoyment covenant. Again, won't go into that. We're getting to legal areas, which I'm sure you don't want to hear too much about. But the fundamental point here is that if you're bringing a claim for a breach of a quiet enjoyment covenant, you probably should be thinking about whether you should be bringing a claim for certain other points to be built into it. If you're already having a fight with the landlord on one thing, you might well be having issues elsewhere. There might be other breaches of the agreement that you might want to bring into play, just because it's cost effective to deal with it all in one basket rather than a range of separate claims. In terms of the process, in your tenancy agreement, you may well have a particular disputes clause. This might prescribe the way that you have to carry out a claim. That might be, for instance, by arbitration, which is typically the route for Agricultural Holdings Act tenancies. You typically have to go through an arbitration route for that, and that's not necessarily a bad thing. Courts are all public, arbitration is confidential, and you can also have more streamlined directions for how to manage the issue in an arbitration, so it can end up being a bit more cost effective, resolved quicker, a bit cheaper. You might also deal with certain things through the tribunal or an expert determination, some other forum. So the point is, have a look at what your agreement says. If it's silent, you probably have the option, but your solicitors can certainly advise you on how to manage that. The process itself is like most other claims. You're bringing a damages or injunction claim. You'll be expected to have sought to resolve the issue with the landlord first, failing which you issue a claim and you go through the process, which you may or may not be familiar with, but you put forward your case in the form of what we call a statement of case, and then you follow a prescriptive set of directions set by the arbitrator or the court, which sets out disclosure, where you have to find documents and share documents which support your case or hurt your case. You prepare witness evidence to support your claim, all leading to an ultimate hearing. If you have a shorter process, you might well find that a more narrow set of issues in an arbitration can be dealt with by purely written submissions. That's often quite a bit cheaper, so it can be suitable for the smaller matters. Which leads on to what does it all cost? And I'm afraid that these things aren't cheap. I don't know whether you have had much experience with litigation before, but if you have to go the distance in a fully contested court process, or indeed many arbitrations, you are most likely looking at tens of thousands of pounds for solicitors. And in the really complex cases, it can easily stretch into six figures. I've acted in a range of matters where this has happened. I act for numerous AHA tenants, members of the TFA or otherwise, where they're in fights with their landlords, and it's often well into the tens of thousands of pounds. Now, don't let that scare you too much. In more niche situations, you can bring that down quite considerably. If you get, for instance, a really streamlined set of directions in arbitration, it could be in the thousands, which is still a bit unpalatable, but it's a good deal cheaper than you might otherwise get. And indeed, if you were just seeking advice at an early stage, you're probably not going to exceed, £1,000 or £2,000, or indeed less than that. So it is pricey. This is why, and I'm at the risk of talking myself out of a job here, you do not get solicitors involved if you can avoid it. But don't forget, you may well have an insurance policy that you're not really aware of that gives you some insurance cover. For instance, it's locked via the NFU mutual service. Things like that, which you can often get some insurance cover to pay for your solicitors, or at least some assistance in it. And I think the NFU also does a legal fee support scheme as well. So there are routes to try and help you out if you're in a bit of a bind, because it shouldn't be the case that parties who are treated unjustly just have to accept the situation because they can't afford to address it through the use of professionals. Now, the other point I would make as a final one is, if you do have to bring a claim, don't necessarily expect it goes the full distance. Most matters settle early. So you might well find that if you really show the landlord you mean business, if you're not tolerating their actions, they might all of a sudden go, okay, fine, let's have a sensible discussion and resolution there. So by way of summary on my final slide, don't be too intimidated, guys. You will have a right to quiet enjoyment. That's a promise from the landlord to you, and he should not be breaching it. It has to be considered with the terms of your agreement as a whole. That's how the court will approach the picture. But you do have the benefit of protection here. And if you think there's an issue, you should explore whether there's a way to resolve that. And you have a range of ways to test the waters there before you have to start spending the big bucks on really bringing a claim. And if you do have to bring a claim, there are heaps of examples of the tenants successfully doing so. So don't be alarmed that it all seems like a far too difficult battle. It can be done. And so, without further ado, I'll pass back over to Robert, and we can hopefully move on to the Q&A stage.
Well, that's fantastic, Harry, and thank you for a very clear and concise run through our subject this evening. Before I do hand over the question and answers, I would just want to remind everybody that if you do have a question for this evening, then do put it into the question answer box at the bottom of the screen, and then we can pick that up with George and Harry as we get into questions. So I think at this point, if I can ask George to come in at this point, and I know that we have a number of questions that have been submitted prior to tonight's webinar, and if George, I ask you to come in and we'll kick off with those first, please.
Yeah, thanks so much, Robert, and thanks, Harry, for the clarity of your remarks earlier. As Robert has said, we've sort of packaged together a few themes which have been raised with us in advance of tonight's webinar, and I'm going to try and put those to you in some format, and hope you can provide some insight. So, in terms of what the tenant might be able to do proactively to protect against a landlord breaching the covenant of quiet enjoyment, what sort of things would you be advising a tenant farmer to be thinking about to stem off a potential breach?
Well, I think the first answer to that really is coming along to things like this. Make sure you're aware of what your rights are and what your options are. So have a look at your tenancy agreement, have a think about what you might be entitled to, and then you will have the framework of where any such breaches might arise. And then you can try and extrapolate whether or not there is a breach occurring from whatever the actions are. If you think there might be, speak to relevant people like the TFA. You can start keeping a log of events. One of the first things that I will ask for new clients is, can you give me a concise summary of the things that have gone wrong? It's really helpful when we have clients who've essentially got a dated chronology of the issues, because it really streamlines my work to get up to speed, which then helps reduce the cost.
I'll come on to that in a second, but one of the things that you mentioned in your remarks in terms of at least preparing for a potential problem is insurance to defray the costs
Mm.
involved. Now, you mentioned one particular provider. I would say other providers are also available, including the TFA's legal expenses policy that we have with Licensed Legal. So Licensed Legal have a policy which our members can acquire, and that does give them cover for this type of issue. So that's really important. But in terms of a situation where a tenant is beginning to be concerned about a landlord breaching that covenant of quiet enjoyment, at what point would you encourage a tenant to begin to collate that information and to annotate that evidence into a breach of quiet enjoyment, and over what sort of a period of time or intensity would you think it's reasonable for the action of the landlord to be considered to be a breach of the quiet enjoyment?
It's difficult to answer that, George, because it does get so fact specific, I'm afraid. I mean, I think if you're getting to a point where there's actual damage being suffered, where your trade or business is being inhibited, then that's absolutely the point where you really need to think about taking steps, because you shouldn't have to suffer through that just because the landlord's throwing his weight around. But if equally, if you think that's a situation that might arise but hasn't yet arisen, that's probably the trigger point. It's when there's actual risk of you being out of pocket, or your work being at risk. Um, it, I think that's all I can say in relation to that. It depends, but think about the damage and when it might arise.
Okay, and you talked about injunctions as being an extreme basis for stopping a landlord doing something which is clearly a breach of quiet enjoyment. In other language, in other legal language, sometimes injunctions are seen to be an interim solution rather than a final solution. But are you saying that these injunctions can last for the length of the tenancy, and if the landlord breaches that, then they could be, as you say, in contempt of court? And what sort of a cost would there be in terms of getting an injunction in place against a landlord who is in that position?
Oh, there's a couple of questions there. So I'll try and take them in order. So you made a very correct point in relation to interim relief being a common form of injunction, and that's quite right. You'll have injunctions to essentially try and hold the ring. So it's often used in the context of a wider dispute where all of a sudden there's a risk that the status quo is about to be derailed because of some action or some inaction, and that's when the interim relief from injunction might well be applicable. But that's not to say that you can't have a final injunction order, and indeed the court does award them. They are reluctant to do so because the court doesn't want to give such a draconian remedy. You really have to show that it's necessary. But it does happen, and it will happen in circumstances where one party, whether the landlord or the tenant or anyone at all, is acting in such a way that the court feels it is necessary to restrain them in such a way. So in really severe examples, you will find that you can get a final injunction order. Um, as to what it costs, if we're just talking about interim relief, these tend to be very urgent applications because by their nature, they have to hold the ring. They have to act very quickly and they really do have to be urgent. We will normally tell our clients, I mean, if we're plucking a figure out of the air, I would probably quote somewhere between the region of 25 to 50,000 pounds to obtain the interim relief and injunction. It is substantial, but they are complex issues. There's a whole range of legal tests that you have to meet. You will need barrister support because you'll need to go and have somebody to appear for you, likely in the High Court. And that, I'm afraid, costs a lot of money, and it's all very urgent. So you're asking people to essentially change their whole schedules to fit around this. And it can be done, but it's pricey. For a final injunction, you're talking about the whole process of essentially a claim. That's the ultimate remedy at the end of the long claim. So it's the whole cost of a claim in the tens, if not hundreds of thousands of pounds, because that's quite a strong thing you're asking for. So it will be an expensive one.
Yeah, that's a pretty spicy level of fees that you're quoting, Harry. And yeah, that will be out of reach for many people in terms of trying to get a final resolution to the situation. But obviously, it is the nuclear option which is available to people if it has become a huge issue. Have you got any examples of where you've seen these types of injunction operate within a landlord and tenant system? May not be in an agricultural field, and maybe in a commercial or other field. But any
Yeah,
examples?
no,
Yeah.
there's what I've actually had quite an interesting and timely new matter that's come across my desk where this is being threatened, which has prompted me to do a little bit of legal research. Which it's a commercial situation, but apparently it's one that I'm learning occurs quite a lot, where you have a landlord that, for instance, has the freehold for a block of buildings, and you might have, particularly in a city, the ground floor dedicated to shops. But all of a sudden, the higher facade needs to have work done to it, and that necessitates quite heavy duty scaffolding. And as you can imagine, if you have scaffolding in place in front of a shop, a restaurant, what have you, their trade or business is going to be interfered with. It's quite likely that there will be some loss in the form of reduced income coming in. So there are instances of those tenants successfully seeking injunctions to remove the scaffolding or to prevent it from going up in the first place. There's certain cases such as Century Projects and Almacantar was looking at before, and a range of others. So it happens. And I would suggest it happens probably more often in commercial, just because I think there's
Yeah,
quite a few more
absolutely.
commercial matters going around. There tends to be a bit more money in those as well.
But you can see a circumstance where, for example, a landlord might retain ownership of some land next door to your farm where you've got a lease or a tenancy, where the landlord is then seeking to carry out some works of development on that land, which then
Mm,
restricts your access to, for example, a tanker coming to pick up your milk, or your visitors coming to the farm shop or whatever. You can see circumstances where a similar sort of thing might arise, and I know there's plenty of case law in the commercial sector, as you say. So, yeah, I think people just need to be mindful of the fact that just because it's happening on the landlord's other land, it doesn't mean that it can't be deemed to be a breach of your client enjoyment if it's affecting the way in which you're using the holding from the same landlord. That's the correct analysis, isn't it?
yes, exactly. I mean, normally with the quiet enjoyment covenant, the common scenario is it happening on the tenant's land rather than an adjacent land. But that's not necessarily a barrier, because if it's the landlord's adjacent property, or for instance, the case I mentioned before, the Sanderson and Berwick one, it's adjoining properties ultimately owned by the landlord. So any of those circumstances can give rise to this sort of breach scenario, which ultimately can lead to an injunction.
So I've just got a couple more questions left. So if anybody on the webinar tonight has any questions for Harry, do please feel free to put them in the Q&A, and Robert will pick those up when I've finished being Michael Parkinson with Harry tonight. So looking at the beginning of an agreement, so this is where a landlord and a tenant are beginning to draw up an agreement, which we would always advise people take advice on, and to do it on a bespoke basis rather than just taking a template from a website somewhere. What sort of things should a tenant be considering when they're drawing up a tenancy agreement in order to ensure that they are protecting their position in terms of the landlord's covenant of quiet enjoyment, rather than just having that bland phrase? What sort of things would you be
Hmm.
encouraging the tenant to be considering?
Well, I alluded to it earlier on in my talk. You can have an expansion or narrowing of the quiet enjoyment covenant. Now, this only really goes so far because the fundamental basis doesn't really change. But one of the things tenants might want to make sure is, if, for instance, you're a subtenant, you want to make sure that this covenant, as far as possible, extends to actions from the ultimate landowner. So if you're renting from a tenant themselves. You want to make sure that they are also bound in this agreement by the actions of their ultimate landlord, because otherwise you can have a scenario where you will have to go outside of that contractual relationship, which just makes things a bit more complicated. It doesn't avoid the option of taking action, but it wouldn't be via a breach of quiet enjoyment, because that's only in relation to the person you're in agreement with via the lease. The other point, which I think is very, very important, and I'm sure there will have been various talks that you may well have been to before about the reservation of rights that a landlord might have in this. But as I mentioned before, it really does interplay quite carefully with the quiet enjoyment covenant, and you do need to be quite cautious about what rights you are giving the landlord, because especially these days, landlords are very savvy about knowing the pitfalls to avoid on their point of view, to give them as much control and protection as possible. If, for instance, they wanted to secure planning permission to take back the land or something along those lines. So things like rights to enter and carry out surveys, particularly intrusive ones, boreholes, things like that, can be very important for the landlord. And also, it might not matter too much to the tenant on the face of it, but then a few years down the line, you might find that you thought you had a really great tenancy, long-lasting, really great security of tenure, but all of a sudden, because the landlord's able to come on and do those surveys, all of a sudden they can get planning permission. As a result of planning permission, they can serve a notice to quit to get you off the land, which can be quite unpleasant. So you do need to be careful about those sorts of agreements. And I would stress, as you have said, go and speak to a specialist about this, and make sure that those rights aren't too extreme, to make sure you're not setting yourself a problem further down the line.
Okay, and then finally from me, Harry, and this is probably linked with the concept you were talking about in terms of derogation from grant. So where you have a tenant who has got a very sensitive use of the holding, which might require very high biosecurity. We know some poultry units and some pig units and some dairy units where they're flushing embryos and things like that, or can be quite sensitive. Even though the landlord has a general right to come onto the holding to look at, the condition of the holding and all of that normally within a tenancy agreement, a tenant in those circumstances, are they able to prevent or restrict the landlord's access to ensure that their biosecurity can be maintained if that's the use of the holding?
In a word, absolutely, in my view. I think the expectation is one of reasonableness. If the landlord's wanting to come onto the land to inspect or to carry out certain duties or rights or what have you, then there will be an expectation that they do so with a minimal interference to the tenant, and that absolutely applies to scenarios where the tenant has specialist requirements, such as biosecurity. If the landlord wants to come in and look at poultry sheds, maybe they are ultimately the landlord's buildings, using the example you've said. There'll be expectation they'll need to have, have a shower, put on the proper gear to make sure they're not contaminating anything. If they want to just show up in their tweed with their agents, then it's not going to work. And the tenant is absolutely correct to try and prevent their access there. That might flare up into an issue, but as far as I'm concerned, that's something that you can defend quite well. You've got good ground to reject that.
Thanks, Harry. Robert, over to you.
Well, thank you both. That's been quite entertaining listening to where you go through on that. It's quite interesting. I was sitting here. So we've been tenants for over 100 years where we are, and it's something that's never even arisen with us. And I don't know why that was. We were on a secure tenancy, of course, but whether we had just a very good working relationship with the landlord and the agents, I don't know how it was. So I suppose the question for me to kick off is, how often are you kind of getting questions coming in from tenants as to this kind of situation, Harry?
Well, quite frequently, I think is the short answer. I must admit, the amount of matters that I've dealt with concerning strictly quiet enjoyment is essentially nil. It's always alongside some other points. It's always alongside some other bigger breach, and you normally bring along that as an example of how the landlord's actions are interfering. So it normally happens ancillary to other disputes, I would suggest. And unfortunately, that does happen quite a lot in my day-to-day work. We are quite busy. There is no shortage of landlord and tenant disputes, unfortunately.
And is there much of a difference between what I would call an institutional landlord or a private landlord? Is there much of a discrepancy difference between the two? Where
I
you,
definitely,
yeah,
I definitely say so. Yeah, I think it mostly comes down to how easy is it to go and have a sensible, practical discussion. And I think especially when you've got a private landlord, especially if you know the person, and tenants and their landlords frequently have great relationships, and their families have known each other for generations. And there's often kind of a bit of a code between them. If you can go and say that this is causing a problem, and you've got that relationship to rely on, often it doesn't go any further, and you can fix it then and there. I think that has gone away in recent times, and especially with the rise of land held by trusts and trustees, because they're very much viewing the situation with a eye on their duties as a trustee to essentially maximize the value of the land. And it does cause problems because I often think you're kind of losing the humanity of these situations. You're viewing it purely from the perspective of what is the most productive use of this land for the purposes of the charity, of the trust, what have you. And often that's get it into a development, get the tenant gone. Doesn't matter that they've been there for 100 years.
yeah.
We need to get the most value out of this, and that means whatever we can to get rid of them. And it's a real shame because sometimes this happens after you've had, the former landowner who had a great relationship with the tenant. Maybe they've passed away, and they've put it into a trust to look after the land and their family and their beneficiaries, and the trustees. And you understand why are taking actions which seem a bit callous. So you do get this difference between private and commercial or trust landlords, I think.
And I think, Robert, as well, it's a symptom of a breakdown in relationships normally. So, I mean, Harry said it's normally connected with other things that are going on. But obviously, if a relationship between a landlord and the tenant, or between the landlord and the landlord's agent and the tenant, becomes distant for whatever reason, suspicion begins to build within that gap. And the parties are both looking at what the other one's doing and looking at it in a way which is perhaps not the reality of the situation, but it looks like people are trying to second guess what's going on. That means every time the landlord's agent comes onto the holding, you think, well, he's doing something or she's doing something which is against my interests. If we have this, the mantra which we have as an organization, Robert, you will know, is that landlords and tenants need to build relationship, and the new landlord tenant code of practice drives people towards making that relationship.
Yeah.
And then there's a greater understanding, greater clarity, greater communication, greater collaboration between the parties, and these sorts of things about quiet enjoyment become less important to people. But so we are frequently having conversations with TFA members who feel that the relationship with their landlords become distant, and as a result of that, all of the actions of the landlord appear to be a breach of the quiet enjoyment because of the way in which they're being handled on the holding. So yeah, it is often due to other factors sometimes.
It's interesting to say that, George, because it's reminded me back to our conference we had down at the Crown Estates and the new 15-year environmental FBT. One thing that Paul Sedgwick made very clear that day at the conference was it's all about relationships. It's all about talking. We understand that what the tenants are looking to achieve. We're helping them achieve it now with this thing. And I thought that was tremendous there, actually, alongside the code of conduct as well. And everything's all built into one shiny new thing, as it were.
Yeah, exactly. And Paul Sedgwick, who's the director of rural and the Windsor Estate for the Crown Estate, it is one institutional landlord that is attempting to break the mold of the poor relationship that we have seen in the past. And those watching the webinar will be pleased to hear that it didn't stop at the conference at Windsor at the beginning of May. So today I was back with the Crown Estate at Windsor with all of the managing agents talking about building relationships with tenant farmers. So you're absolutely right. We are making inroads every day to build better relationships so we avoid these types of problem occurring.
I think I said in my closing remarks at the conference, it's a benchmark. for everybody else to aspire to. And I think from the conversation you and I had, George, with other landlords, they're very much looking to replicate that, and to be. We always said it's the relationship between a willing and prudent landlord and a willing and prudent tenant. So it's what we aspire to at home anyway. So I just want to remind everybody, questions, if you put them into the Q&A tonight, and then we'll hopefully be able to answer them for you. So the first one here is from Francis. And is it acceptable for landlords to come onto the farm and not allow the tenant to accompany them?
I don't think it's really a question for them as to who accompanies them. It's your land and you've got the use of it. If you happen to want to be there as they inspect, that doesn't seem unreasonable to me at all. It would be quite an unusual tenancy agreement which prohibits something like that. But again, I suppose sometimes it's a bit of a balancing act. You know, if you're going to rub the landlord the wrong way by kind of demanding that you watch exactly what they do, it's not the sort of trusting relationship that you two would both just kind of explaining we really need to work on. So be mindful of that sort of thing. I don't see a necessary problem with that, but just be considerate of how it might be perceived.
No, well, I would say generally, why would a landlord not want to be walking around the holding with the tenant? Because
indeed,
invariably, the tenant will be more knowledgeable about the holding than the landlord or the landlord's agent because they are there 24/7. They know it intimately. So I would be suspicious of a landlord that said, I don't want you to come around the holding with me. But obviously, from time to time, there will be the need for the landlord with the landlord professional advisors to take a bit of, shall we say, private intelligence from their professional advisors, and they might need a little bit of privacy to have those conversations in the midst of a farm visit for whatever reason. And obviously, we've got to respect those opportunities that landlords will want to talk to their advisors about something that might be quite sensitive to them from a they may not have the money to do repairs, for example, and they don't want to display that in front of the tenant. That's a reasonable thing that the landlord might want to do. But in general terms, I would agree with Harry. There's no reason why a landlord should say no to you walking around, and I would certainly say if the landlord does want to have an inspection, you should say, well, I want to be there for that inspection and to walk around with you, definitely.
No, well, I would agree wholeheartedly with that, and I think if you can hold the hands nearly and go around with them, it's really going to work quite well, I would have thought, to be honest. We'll come on to our next question here. Our landlord has reserved shooting rights, which are run by a local syndicate. They shoot one field of ours, which we overwinter livestock, but we can't use it until after the shooting season is over in February. Do we have any rights to stop them so that we can use the field from November forwards? Thank you.
I would suggest this is a bit of a question of what was the situation when you entered the tenancy, because normally it will be a question the courts will want to have answered. If you've started your tenancy and this was the original position and the landlord made you aware of that, then I don't think you've really got much of a ground to resist it. If, however, it's come to be since you've started, then it's a bit more arguable because he's unless you've had a specific ancillary agreement that's where you've consented to that, it would seem to me that he's ultimately changing the terms of your lease and affecting the way that you're using the land. So potentially, yes, it's a question, I suppose, of what the damages are from that action. Maybe the cattle or the livestock are slightly less productive because you haven't got them exactly in the way that you want them for the relevant time. But I'm afraid that's a bit of an it depends answer, but without the specific facts, it's a bit harder to go much further than that.
And Harry, we have seen situations where, for example, we have a member who has gone into a tenancy many moons ago, where the landlords have reserved the sporting rights and where they have been used infrequently or not intensively, and then all of a sudden there's a change in the landlord for whatever reason, or a change in the family relationship, and all of a sudden you find yourself with a much more intensively run shoot on the farm. which is causing you problems with the normal use of your holding. And the question is, well, should the tenant have been aware of that at the time the tenancy was entered into, that was a possibility? But I would suggest to you that I would be coming to you for some advice as to what to do in those circumstances where there's been a sudden intensification of the sporting rights. And the other issue that we have frequently is where there is a sporting tenant, and they see themselves as the superior tenant on the land as opposed to the farming tenant on the land, and where they cause damage or where they drive their quad bikes over crops, and they just carry on willy-nilly and carry on regardless. And I believe, you can correct me if I'm wrong here, Harry, but the claim for any damages in that respect is against the landlord, because the landlord's given the right to the sporting tenant. But quite often the landlord will say, it's not my responsibility. It's, you need to go and get that money off the sporting tenant. But actually, it's the landlord who's got the relationship with the farming tenant who needs to sort that out. So sporting rights are one of those areas where there is always quite a lot of conflict.
Yes, and just to pick up on that point, I think you're probably quite right. You would probably have to go on the landlord. It goes back to that flooding point. If the other tenant is acting, within their lawful rights, then it might be a problem that you have to pursue the landlord for. If they're going too far, it might be a separate claim. Wouldn't necessarily be a breach of quiet enjoyment point. It would be something like nuisance and the damages arising from that. But I wouldn't say it's absolutely the case you have to pursue the landlord. But sometimes if the landlord's not really engaging, you might just have to get on and sue them and make them actually sit up and take notice, which is a bit of a unsatisfactory route to go. But it might be what you have to do. In relation to that circumstances point that you made before, yes, ultimately we are looking for that change in circumstances from that status quo position. It's the same concept as when you're talking about repairing obligations. When you start a tenancy, right, that's the point in time where the condition is essentially fixed. And so if there's a deterioration from then, that's the change in circumstances we're looking for. It's the same sort of concept.
It's quite interesting to say that, because I remember when I took my tenancy over from my father, one of the things that the agent that I employed at the time was we took hundreds of pictures, and we made sure we had a tremendous document there of everything as it was as we came in, whether it be the fences, how the doors hung, the ends of the buildings, and that was probably one of the best things that we ever did. And I think I've often heard the people say about an issue coming up. I said, "Well, did you take any pictures?" When, "Oh no, we didn't do that." So I think it's also it's within our own hands as well as tenants to make sure that we have a directory there of everything as we walk in the door. Whether it's the house, whether it's the buildings, whether there's land, the hedges, fences, whatever it is, so that if somebody comes back to you, at least you always have something to relate back to again.
No, absolutely. It's hugely helpful if I have to pursue a claim when the client's got such a thorough set of information like that.
Yeah, I think my agent said, "Goodness me," because he had a wood business as well. He says, your fences are looking tremendously good at the moment. He says, "I wish you'd just come to me, because I could have provided even some more posts for you there." If we, it's amazing what some of these agents will tell you. If we can lead on to our next question, we currently farm under a tenancy which is an HA pre-95. With a statement, we have a right to quiet enjoyment. I was wondering what the situation was with the landlord turning up on the land without us knowing, them taking pictures just of day-to-day activities. But it's there again, it's back to this thing again of without us knowing. They never visit the property, only parts of the land. So I don't know how that could be kind of answered on your behalf there, Harry.
Well, that's a little suspicious, that sort of conduct, because it seems a bit underhand, doesn't it? So I would be a little cautious about what they're trying to do there, and it doesn't signify a great relationship. Obviously, as an AHA tenant of that sort of thing, you've got very good security of tenure. So you might find that landlords just trying to come on and get some information about the property, maybe to inform some further goings on, but they really should be giving you notice. And it doesn't seem unreasonable to me at all to say to the landlord, please, if you want to come to the holding, make sure you tell us, at least 24 hours in advance. That should be the bare minimum they should do. It's quite difficult though to cause too much of a stink about that, because you can complain and say to the landlord you shouldn't be doing that, but if they're going to keep on doing it, you might eventually have to take quite draconian action to stop them on something which, on the face of it, might not necessarily be causing that much damage. So I do empathise with you in that situation. It could cause some stress.
We have had situations, Robert, referred to us with members who have been experiencing drone activity from their landlords on their farms, taking pictures of what's going on and taking videos of activities, and concerns being expressed about the drones spooking livestock and causing problems with livestock. So whilst it may not be technically illegal or a breach of the quiet enjoyment to have drones necessarily, but they can be a nuisance, and they can in extreme circumstances be a breach of quiet enjoyment if they do cause livestock to break through fences and stuff. So I think it's something that we just need to be mindful of in terms of the new technology that there is around as well.
I think I know what my father's answer to that one would be, George. I think he was taking it down with his 12 bore, and but I don't know how legal that one is, to be honest. And,
Harry, what about that? Can we shut it down?
Well, if nobody knows about it, obviously I can't condone such things.
No, absolutely not. No, we couldn't possibly comment on that sort of activity, Mr. Chairman.
No, I think we'll have to have a caveat in there at some point, actually, just to cover our legal indemnity, George. And but it's quite interesting. We've had even just a comment in here and saying that from Mary, and say that. I've kept a landlord diary for the last 5 years since I became aware of intense interest in our farm buildings. We are now fighting a planning application on the buildings. So I think that's the thing there. I've taken notes, taken plenty of pictures, and just trying to cover yourself.
Absolutely.
Yeah, I think people just need to be. My one plea is we recognise that landlords and tenants will sometimes have different interests on the future of that holding. So some landlords will want to look for development, as Harry was saying, and tenants will want to object to that. But in the knowledge that those types of issues will arise, for goodness sake, let's just be honest with one another. The landlord does have different aspirations to the tenant. If the landlord wants to consider, thinking about how that holding might be used differently, what's there to lose by being upfront with the tenant to say that this is something we're considering down the line? You might see some people coming along. There's no reason to be so secretive, and that's what breeds this type of activity sometimes, where people feel that they are being put upon for a breach of quiet enjoyment.
No, I would agree with you there. And it costs nothing for a phone call or I would rather have a call or knock on the door than an email. At least you're showing an interest in the tenant, you're showing interest in the farm, and I think that the landlords would learn a huge amount by just going to go and talk to the tenant.
Yeah, it's all about putting yourself in the other person's shoes and respecting the sanctity of the place, because quite often it's the tenant who is running the business, but living there, bringing their children up there, having the family there, and it's about understanding that situation as a landlord and the landlord's agent. But it's also the tenant thinking about what it means to the landlord in terms of that property. So if we can always think about what it means to be in the other person's shoes, we would probably keep the lawyers from our door. Sorry, Harry.
No, I'm all for it. Talk me out of a job.
Well, to be honest with you, I think that sounds a very good point to bring tonight's webinar to a close. As ever, we always have more questions than we have time to ask, of course. And I know Harry's more than happy to answer any afterwards any more questions we have in the question and answers. So in closing, I would like to thank tonight's speakers, both Harry Russell and also George Dunn, and also to our event sponsor, Roythornes Solicitors. I've learned a tremendous amount tonight. I really have, and I hope everybody that's been logging in tonight also has. So before we do sign off, next month's webinar is Preparing Your Farm Business for Inheritance Tax Changes, and that will be held on Wednesday, the 9th of July. This is one that I've really been looking forward to, because we need to be well prepared for what's going to happen down the line. It will feature our expert speaker, who is Andrew Vickery, who is Head of Rural at Old Mills Accountants. Andrew will lead us through the expected impacts of the changes and what can be done to mitigate the tax and when the changes are introduced. Don't forget to register in advance by clicking on the listings in the events calendar on the TFA website, tfa.org.uk. We hope that you found this evening's discussions insightful. Thank you for joining us. Join us next time, and good night.